Hi, this is Jonathan Armstrong from Punter, Southall Law. Thanks again for joining us for another TechLaw10 podcast. And I'm delighted to say that Eric Sinrod is with us live from his home in California. And you've got a somewhat local issue. AI law changes in California. I suspect local, but might affect the rest of the world, Eric.
Well, as California goes, so goes the world, right? We have Silicon Valley, we have our world famous San Francisco 49ers. So let's get moving here. So 2025 marks an interesting year, Jonathan, in California, where California seeks to be a pioneer where it comes to AI laws. And we've seen a series of significant AI laws going into effect, actually about 18 of them. So my intention right now is to tick through some of them at a high level, just to get a sense. This is TechLaw10. We can't drill down super deep, but you'll get the idea. And then I'd love to hear from you in terms of sort of the rippling effect across the waters, what you're seeing in England and otherwise internationally. So we have Assembly Bill 1831, and that provides that AI-generated child pornography is prohibited under expanded California laws. We have AB, when I say AB, that's Assembly Bill 926, and that provides that non-consensual deep fake pornography is criminalized in California. We have Senate Bill 981, which requires that social media platforms must address sexually explicit identity theft. Let me turn my page if you don't mind. I don't have them all completely memorized. I'm a human being, I'm not AI. We have AB 2602, which safeguards against unauthorized digital replica use in contracts. We also have AB 1836, which restricts unauthorized commercial use of deceased personalities' replicas. AB 2655 requires large online platforms to block deceptive election content, including deep fakes. And there's a number of these election type new laws. AB 2355 requires AI-generated political ad disclosures to prevent voter deception. Moving into another space, AB 3030 mandates healthcare AI communications to include disclaimers and contact info. Just a few more, if you don't mind. Mm-hmm. Or I'm like one of the San Francisco 49ers moving the ball toward the goal line. I know that's not your sport. Senate Bill 1120 establishes that only physicians can independently decide medical necessity, not AI. Senate Bill 1223 requires consent for processing neural data. We have AB, sorry for all the numbers, but there might be some folks that are interested in following up on their own. AB 1008 clarifies that personal information under California privacy law includes abstract digital formats from AI. And then two more, if you don't mind. Can you indulge me?
Yes.
All right, two more. Senate Bill 942 mandates that widely used AI systems must watermark content to show that it's AI generated. And finally, for now, as part of this little tour of recent California AI law, AB 2905, quote, requires disclosure and consent for AI generated voice messages in calls, close quote. That's what's been happening in California. Tell me about where you're at.
I think it's amazing, isn't it? I know as you know, sat on the New York State Bar Association AI task force, and I suspect you'd find a very similar list in New York State. Certainly a lot of the voter and election related AI measures seem to also being proposed in New York. And I guess it's one of the curses and benefits of the US system that different states are probably going to take slightly different action to address more or less the same issues. I think the interesting experience that we've had over on our side of the pond is, of course, the EU AI Act, some attempt to be somewhat more comprehensive in looking at AI regulation. And of course, some of those provisions are now in, banning the most egregious AI-related practices. But I don't think that will stop legislatures in Europe adding to the EU AI Act with specific provisions relating to elections, for example. I think the hope with the EU AI Act was that it would bring some form of uniformity across different jurisdictions, almost like the GDPR effect, if you like, of GDPR setting a standard that other jurisdictions aligned with. That doesn't seem to have been as successful with the EU AI Act versus GDPR. I think one of the reasons for that is that whole technical bit we've discussed before about adequacy decisions. It was helpful to countries like South Korea, to Japan, to follow the GDPR model, because then they had concessions through the adequacy findings of the GDPR regime. But there isn't quite the same incentive, I think, under the EU AI Act. And at the same time, many people are questioning whether overburdensome AI regulation fetters innovation and means that the EU, for example, has lost competitive advantage. I think that's why we've seen the UK, for example, under Peter Kyle, the relevant minister here, try and tread a slightly different line, which is seen not to hinder innovation and hinder creativity, but at the same time putting some sort of a regulatory framework in place. And I was interested to see that Anna Zeiter, for example, of eBay, was saying similar things, I think, that there hasn't been the same trickle-down effect with the EU AI Act as there has been in other legislations, but with GDPR specifically. But I guess one of the other things I'd say is that it isn't the Wild West, even absent the EU AI Act. We, as you know, track AI cases across Europe. There are more than 20. They've involved some well-known and some less well-known AI applications, ReplikaAI, Google, Deliveroo, Foodinho, ClearView, Budapest Bank, X, the artist formerly known as Twitter, OpenAI, have all featured in GDPR enforcement against AI applications, and that has been replicated in other jurisdictions. That wave of enforcement activity. Obviously, the original ClearView investigation was a joint investigation between the UK and Australia. South Korea, for example, just last week has followed regulatory activity using privacy legislation against Deepseek. So there clearly is a whole body of enforcement activity relating to AI already. But maybe one last thing I'd say is that AI is obviously an opportunity as well as a threat. And the obligation, I think, on regulators, on prosecutors, but also to corporations as well, is to get that balance right. My suspicion is that some people are not looking at the opportunity aspects of AI because they're concerned with the threat. And I think we will get to cases where corporations particularly are being criticized for not exploring AI. Under UK companies legislation, for example, it's at least very arguable that a board of directors should take AI into account when looking at the future prospects of the corporation and the opportunities, etc. And I think there's definitely a need for corporations to understand AI holistically, looking at opportunities as well as threats. And I wonder if there's any factor of that in the California legislation, given that California's perhaps the most entrepreneurial jurisdiction in the world, are home to many entrepreneurs, those that haven't moved to Texas.
That's a lot packed in there. let me unpack just a little tiny bit to keep us somewhat toward the 10. I think there is a recognition under California law, and again, it would take time to get into it, that while seeking some level of protections through these new legislative actions in California designed around AI or addressing AI, the idea is not to completely make things so cumbersome that companies, and tech companies specifically, can't do what they normally do. This is one reason why California is considered one of the most economically robust and technologically advanced states in the country. So I will say that. Then I want to address one of your points, if that's okay, and then ask you a question.
Yeah.
The uniformity is interesting because oftentimes our states take the lead, especially when it comes to technology and then laws that address advancements in technology. I mean, generally I say technology advances, at warp speed, whereas the law is relatively glacial to catch up, and that's especially true with our federal laws. And it reminds me of when we first were dealing with so much unsolicited commercial email spam, and the states were coming out first in terms of how to deal with that. I think 26 states had their own laws before the federal government ultimately enacted the CAN-SPAM Act of 2003. But at the time, before that federal law, I would advise my clients, please follow the law of Delaware, because we know law of Delaware, because communications and transactions, et cetera, they don't know state boundaries. They're everywhere. So if you follow the law of Delaware, you're in good shape, because at the time it was the most strict. And if you could pass muster under Delaware, you'd be okay. I'm curious whether that's going to be currently true, perhaps with California right now taking the lead, and others might follow suit. Of course, you were talking about New York, and then, what is our federal government going to do? My question is, and I'm really curious because we see Deepseek exploding, right? And you mentioned that ever so slightly. Can you elaborate just a little bit more in terms of privacy concerns and what's being doing about it regarding Deepseek, please?
Yeah, I think there's a number of actions and threatened actions against Deepseek. From my mind, it started with Garante, the Italian data protection authority, and they asked, I'm very much paraphrasing here, but they asked Deepseek some questions about their AI operations, where were they getting training data from, et cetera, et cetera. I don't think there's anything particularly unusual about that. Obviously, they'd asked OpenAI similar questions about ChatGPT. I think the reply they got was more or less, where a Chinese entity, or I think more accurately, two Chinese entities, none of your business, Mr. Garanta. Now that's not usually a great reply to give to a regulator. And those that investigation moved pretty quickly. I think the same day as they got that reply, they launched a formal investigation. Now, these things will take time, but the Garanta has brought a number of AI related cases, as I say, OpenAI, one into a local government in Italy, where there was a European Commission funded AI project that they had concerns about, et cetera, et cetera. So the Garanta, to my knowledge, was first out of the blocks. But then the South Korean authorities seem to have concluded their investigation more quickly. It's probably, we don't have the time to go into that in detail, and maybe in the show notes I'll post a link to the South Korean privacy regulators' action. My understanding is that Deepseek have said just yesterday, I think, as we're recording this, that they're prepared to accept the South Korean regulators' findings. And that's things about transparency, clearer opt-outs, et cetera, et cetera. So I think that there is definitely an opportunity for privacy laws to be used to restrict some of the most concerning aspects of AI. And that will be in terms of things like data collection, where is the training data coming from? How do you correct manifest errors, people who are accused of murder when they didn't commit the murder? How are you allowing people to exercise other data protection rights to opt out, etc.? And how are you ensuring the accuracy of the data that you're using, even absent complaints from individuals? So a lot of the activity, I think, is going to be, at this stage at least, around areas like training data and misuse of data, and data being used for purposes other than that for which it was originally intended. The Grok action against the action against Grok in Italy would be a flavor of that as well, for example.
Very good. Well, I believe we're probably past our 10. This is obviously a topic we will be continuing to talk about, maybe even the next time, picking up on some of the matters you just mentioned. But let's suffice it to say, the AI genie is far out of the bottle. And we're going to see. It is. And we'll see where the law goes to try to deal, right?
Yeah, you're right. But it's not a genie we can ignore either. And I think it is something that organizations have to look at the good and the bad and have a way of dealing with risk rather than just avoiding it.
Absolutely, 100%. Okay, well, to conclude, my name is Eric Sinrod, San Francisco office of Dwayne Morris, LLP. My email address is ejsinrod@dwaynemorris.com. We enjoy doing these video podcasts for you. Jonathan, it's wonderful to see you again. And for me, I'm signing off and saying thank you.
Well, thanks very much. I was just looking around my room to see what I've got that recognizes London. But having drawn a blank, I'll just say I'm jonathan.armstrong@puntersouthall.law. We'll put our contact details along the bottom of the screen. We'll add some notes into the YouTube version. And all that remains is to thank you all for listening or watching.
Hope it was. I was wondering whether a bird was flying around in your room. Okay. All right. Thank you very much.
Thank you.